This is the state attorney general's office response to Tory Lanez's habeas petition, alleging that I think we've seen a lot of that on the internet about this statement from the driver being new evidence. First of all, the statement from the driver has been out since December. I did an article on it back in December because it makes up the bulk of this habeas petition that Lanez's appellate team filed back in December. But this is the state attorney general's office responding and saying, actually, that isn't new evidence. And they're pointing out that Lanez's own attorney talked about how the attorney or how the driver would testify during trial and just said, we don't think we need to call him. So that right there, I think kind of tanks that argument. But and a lot of these, they're getting into a lot of case law here, not specific to Lanez, but they're talking about the legal standard here for granting a petition like this, and et cetera, et cetera. Yeah, and that's what this is an informal response. It's like, it looks pretty formal to me. I don't know. But all this case law, it's all typed up. It's totally formal. But it's a legal term in the appellate courts for what it is. It says the purpose of an informal response is to assist the court in determining whether the petition states a prima facie case for relief and whether any of the claims are procedurally barred without requiring formal pleadings, the return and traverse, or conducting an evidentiary hearing. If no prima facie case for relief is stated, the reviewing court must summarily deny the petition. In contrast, if the court finds the factual allegations taken as true, establish a prima facie case for relief, the court must issue an order to show cause, which indicates the court's preliminary assessment that the petitioner would be entitled to relief if his factual allegations are proved. And that would lead to some kind of evidentiary hearing or further proceeding or something. And this is the AG saying, we don't even need to go there. It should just be summarily denied right now. So, yeah, and it says it requires that the new evidence be discovered after trial, and that the evidence would be sufficiently material and credible that it more likely than not would have changed the outcome of the case. And they're saying this supposedly new statement from the driver, Quan, fails on both counts. And in the petition that was filed in December with that declaration from Quan, they concede that they, of course, were aware of Quan back during the trial and considered calling him as a witness before declining to do so. But then the AG says, without citing to any supporting documentation, the petition simply alleges, quote, it was unknown until this time what Smith had witnessed and what he would have stated. And it says this conclusory allegation, which provides no underlying facts on which the assertion is based, cannot warrant relief. Smith's declaration provides no support for the petition's conclusory allegation. The only portion of Smith's declaration that bears on the timing issue is the final paragraph, which states, I wanted to present this evidence during Mr. Peterson's trial, but was presented from doing so as the district attorney was not ready to cross-examine me, and later they did not call me due to the holidays in the court schedule. I believe I should have been allowed to present this evidence at trial. But this declaration does not address whether Smith had any conversation with defense counsel regarding this expected testimony. This is the AG's response to the new evidence argument. Petitioner's failure to allege facts and the timing issue is further evident in his failure to provide a declaration from trial counsel on the matter. Yeah, they're saying if this was really an issue, Mgdesyan should have issued a declaration. Oops. Let me pull that back here. It's the motion for relevant evidence. Yeah, here's the informal response. So again, it's going to be a while before the court actually decides this. There's really no saying. I was hearing from somebody that, it'll just collect dust until next year. But I think it's possible it could maybe get up for oral argument before the end of the year. Maybe, I don't know, probably not. But yeah, what, 4 months left, 5 months left? Because Tory can file, his lawyers can file an optional reply to all this, and then an oral argument. So maybe early next year, oral argument, but it could be a while. But this is the first time we've seen like a substantive response from the AG's office to any of this. So yeah, here's and again, this is regarding Kwan's new statement. Kwan's statement was filed back in December, and they were alleging in the petition that, we had no idea he was going to testify this way. But then the AG's office went and actually got the transcript from a meeting Tory's trial counsel had with the judge that shows they did know how he was going to testify. So here it is. It says, in any event, the sealed transcript of an ex parte hearing the trial court held with defense counsel refutes the petition's allegation that prior to the post-trial habeas investigation, it had been unknown what Smith had witnessed and what he would have stated. In that ex parte hearing, defense counsel acknowledged that he had spoken with Smith regarding his observations and determined that Smith would not be a helpful witness. Specifically, defense counsel explained, we came to the conclusion that we're not going to call him because obviously his testimony is going to be putting the gun in the hands of Kelsey. And that's what he told all of us when we just did an interview upstairs. At this point, my position was that the jury believes our theory. This is George Mgdesyan talking to Judge Hereford during trial. I think Sean Kelly already put the gun in Kelsey's hand. So obviously it turns out the jury just did not believe that theory. And the AG's office goes into why there's so much other evidence supporting an actual conviction here, and that if Smith had testified, it isn't likely that it would have changed the outcome, and Tory would have been convicted anyway, because it points out that Smith indicates that he did not actually see whether petitioner or Harris fired the gunshots that injured Pete, and that's Megan Pete, obviously. And because in his declaration, he says, I was still pulling Miss Pete and did not see who shot the weapon. It says, thus, Smith did not directly contradict Pete's testimony that petitioner was the person who shot her. And it says, moreover, Smith's value as a witness was limited given his acknowledgement of facts showing that he has a bias in favor of petitioner. That's Lanez. Specifically, Smith characterizes petitioner as a close personal friend, and Smith admits that he has depended upon the income he received from petitioner while working as his professional driver and bodyguard. And they're citing an instruction that advises the jury to consider the possibility that testimony of a witness was biased by a factor such as a personal relationship. So the jury would have been specifically instructed. I mean, they were specifically instructed to consider that. But it says, given these circumstances, defense counsel conceded that Smith would not have been a helpful witness because of his bias in the cumulative nature of his proffered testimony. Recognizing that an independent eyewitness had placed the gun in the hands of Harris prior to the shooting, defense counsel explained, that it would not do anything to have appellant's friend say the same. In any event, that we see that a lot in here. If you, Michael C. Keller, the guy who wrote that, and seems to like that phrase, in any event. The compelling evidence of petitioner's guilt precludes him from showing that it is more likely than not that he would have obtained a better outcome if Smith had testified. As noted in the concurrently filed respondent's brief, that is a reference to that brief that I say I'm going to get this afternoon. Pete identified petitioner as the shooter, and her testimony was corroborated by a wealth of other evidence. Specifically, Harris identified petitioner as the shooter in a text that she sent just moments after the shooting, and she again identified him as the shooter during a recorded interview shortly before trial. Although Harris failed to confirm the identification at trial, she remained consistent with respect to her denial of being the shooter. Moreover, within minutes of the shooting, responding police officers found the gun used to commit the shooting under the front passenger seat, where petitioner had been seated when the SUV was stopped. Finally, petitioner implicated himself as the shooter twice in recorded admissions made within 24 hours of the shooting. And that's, of course, a reference to the text messages to Megan after he got out of jail and the apologetic phone call to Kelsey that was recorded because it was made from jail. And Tory says that he didn't actually say anything about a shooting in those calls, but the AG's office basically just says that it's a given what he was talking about, which is what prosecutors argued too. But Tory's argument in trial was that he was apologizing for having this dual interest in Kelsey and Megan that led to, this jealous fight. But obviously the jury rejected that.